Well, welcome back to the committee. We're moving now to our second evidence session this morning, and I would like to welcome Harv Elgar, who's the Director of Friends of the Earth Cymru, and Daniel Thurkelson, who is a campaigner with the Coal Action Network. Welcome to both of you. We will go straight into questions to make the most of the time that we have, and I will ask a question to begin. Could I ask you to explain why you believe the bill is needed and to create a body, considering, of course, that recent work has happened to categorise tips? Local authorities have a role and other bodies have a role to play in this field as well, and there is an ongoing programme of inspection and maintenance work happening at the moment.
Yes, would you like me to come in first? We do strongly support this bill, and we do also recognise that some steps have been taken in the past few years in terms of monitoring, categorisation and working with the current public bodies, but it is a big problem, and we don't think that there's any body or combination of bodies in Wales at the moment that have the capacity or the funding or the expertise to deal with the problems that we face. And of course, this will be a problem that will get worse over time because climate change and the effects of climate change and the extreme weather patterns that we're seeing. So, of course, we've been very aware about the Aberfan disaster for decades. We've been very aware of this possibility. It's becoming more of an emerging crisis, and it's a broader issue now. And we need to take that prevention principle not only to deal with the problems that arise or look at some tips, but one authority that can deal with the problems before they arise and stop this from happening again. I think that would be the strength of having a new public authority that could bring these things together and to ensure that the right sites are prioritised. Thank you very much.
Camtilleri, it shows that there's still progress that needs to be made. Having a dedicated authority to drive forward that progress, I think that there's utility in that, and not making additional burdens on local planning authorities that are already overstretched and sometimes struggling to discharge their responsibility of oversight on large projects.
Yeah. Okay. Diolch yn fawr. Carol.
Oh, thank you. The white paper proposed the bill would protect communities, infrastructure, and the environment, okay, by introducing appropriate management of tips. But the new coal tip safety regime in the bill is based on the protection of human welfare, defined in Section 82. So what are your views on this? And Friends of the Earth, in your paper, you suggest there is a lack of clarity around the meaning of human welfare. Can you expand on this?
Yeah, absolutely. Yeah, we're glad that it's not a narrow definition of human welfare, that it does mention, food and water and energy and transport infrastructure, so that it's not a narrow definition. But we're not clear if it would include sort of key threats like fire and flood, whether it includes pollution and contamination of water, which are directly linked. So we would want to ensure that these hazards are taken into account as well. And of course, all of these could have a big negative impact on nature and biodiversity. So we would be interested to explore whether threat of environmental harm could be included either within that definition or as another subsection to ensure that we do deal with all the serious risks that could raise.
Okay, because it seems like the white paper includes the environment, but then there seems to be an emphasis just on human welfare. So I think that's why I was asking that question.
Daniel, do you want to come in?
I would just add that this bill is narrowly focused on threats to human welfare from stability of tips. I wouldn't want the public to potentially be misled into thinking that it considers all safety aspects of tips, because it doesn't. And I think that is an important point. As Harv mentioned, fire and flooding is not part of this safety regime, except for where it intersects with stability issues.
So Daniel. So your views on whether the definition of human welfare, do you feel that it's appropriate and sufficiently clear? And then are you concerned that it doesn't include those other elements then?
I think it's clear enough. I don't, although where it uses the word serious, and maybe you'll come to that later, I think that needs to be fleshed out. What does serious mean? And I'm hoping it will do as the bill progresses, maybe in the guidance.
Okay, so do you not feel the term serious is clearly understood? And do you consider serious to be a high threshold to be met?
I think that depends on what they illustrate serious to mean later on. I would hope that they do. If they don't later in guidance illustrate what they mean by serious, then I can't pass comment on that, because what does serious mean? So I hope that they will bring out more guidance on that, and at that point, we can ascertain whether that is a suitably high threshold for it to meet or too low.
Sorry, can I just be clear then? So you would explicitly want the bill to encompass the other elements, the environmental, or are you accepting that it's sort of, it's not explicit, but there's...
I understand in the definition of human welfare how that couldn't be expanded to cover everything, and I understand that is sort of an intentional decision to give the bill a narrow remit, but I would be interested in investigating whether sort of threat to environmental harm could be included in the bill as well.
And would there be resource consequences to that as well then, would there?
It would widen what's taken into account. So yes, it would have
So what you're saying is all that would need to be considered as part of that?
Yes.
Okay.
Yeah.
The Deputy First Minister, he said that existing environmental legislation applies, and we heard that earlier. So it's not as unnecessary because the bill is already underpinned by it. But do you think that existing environmental legislation should be referenced in the bill? That's what I was trying to get at earlier,
I do believe, because the bill focuses on people and property, although I accept what the Deputy First Minister says, that the law is the law, of course it applies, but given that the focus of the bill is so narrow, it's not clear, and we would welcome a specific reference in the bill to how all the different processes interact. So what laws apply to the new authority. That goes for sort of planning process and waste processes as well, but specifically with environmental legislation, because it's not included in the bill at the moment, we do believe it's worthwhile to have a reference. We accept also for the argument from the Welsh Government that they don't want to be too specific and need to future-proof the legislation, but there are different ways and different legal tools that can be used to do that, whether it's sort of referencing the most up-to-date environmental legislation or of course, this bill could be amended by future bills. We've got the environmental, I forget the name, Principles and Governance Bill coming up later. That bill could amend this bill. So there are different ways of doing it, but I think it should be investigated to make it completely clear that environmental provisions do relate to this, and that they're not just forgotten in the process. And
there's the whole interplay between primary legislation, regulation and guidance as well, which I know we'll come on to in a minute. Okay. Yeah. Thank you, Carolyn.
Diolch fawr da. I wanted to ask you about some of the potential unintended consequences of the bill, and you've both raised concerns about how there may be scope for unintentionally stimulating remining of disused tips. Could you expand on how you think there's scope for that to happen and what your concern would be about that?
Yeah, I'd be happy to. And I hope that you'll just afford me a little bit of time to go on to this. This is our main concern and what I think is a main weakness of the bill as it stands. So whilst the new bill doesn't add any kind of responsibilities onto landowners, it does make them more enforceable, and it lowers the threshold for acting on maintenance works. So it does introduce some changes that have financial consequences. Caerphilly Council spent 1.8 million across 2 coal tips on maintenance works that were routine and preventative in nature between 2021 and 2023. Those are the kinds of sums of money that we're talking about. And it's why Natural Resources Wales responded to a consultation saying that the bill underestimates the cost of compliance on tip owners or landowners in the case of this bill. There is a coal tip safety grant, but that is only available to landowners that technically cannot pay the costs. Those that technically are able to, sure as heck not going to want to when you're talking millions. So it's still that grant doesn't reduce incentive to avoid those costs for landowners. I know that if I was a landowner, I'd be looking to avoid potentially millions in future costs. However uncertain that is a huge liability. So I would probably try to do one of 2 things, and this is what I think landowners will try to do. To transfer the ownership of that land out to another company. It could be a shell company. We've seen, other guy won't mention names, but we've seen other mining companies doing the same thing, outsourcing the land ownership to shell companies that have no assets to pay that, or to another individual that has no assets to pay for it. There's nothing in this bill to prevent a landowner from doing that. Or 2, facilitate the extraction of coal from these coal tips by a private company offering to do it at no cost to the landowner in return for selling the coal off. And flattening the coal tip in return, so that would avoid any future liabilities. And the landowner, if I was the landowner, I would facilitate that company coming in to do that. The potential impacts of this is it will create a huge challenge for funding these works if the land is sold out to shell companies that can't afford it and it falls back onto the public purse to fund those works. The coal tip safety grant is not set up and not resourced to do that. Local planning authorities may have a deluge of planning applications coming in for coal extraction from coal tips. Even if current legislation is strong enough to prevent those applications from coming through and extracting the coal, it's not going to stop the burden on local planning authorities from having to go through those applications. We know that is a high burden from speaking with local planning authorities, and we know that is a real possibility. We currently have a proposal from ERI Limited in Bedwas to mine 500,000 tonnes of coal. Is what they estimate is contained within 2 coal tips. If you broaden that out to thinking, there's over 2,500 coal tips across Wales, 500,000 tonnes of coal in 2 coal tips, that is a lot of coal. That is real climate changing material if some of those applications even slip through. So we recommend that steps are taken to ensure that landowners cannot offshore their responsibilities to the public purse. We're not policy experts, but obviously speaking to the Law Commission or other bodies, hopefully they can develop a mechanism through which that cannot happen. We also recommend that on the face of this bill, coal extraction under the guise of safety works cannot be approved through planning. As I said, proposals are currently coming forward, so clearly existing policies that are in place are not strong enough. They are not sending the message that Wales is closed to coal mining. And that's what we need. We need stronger policies. We need a coal ban. And at the very least, we need something on the face of this bill to say that this bill is not going to have that unintended consequence of stimulating a new coal mining industry. The UK government's commitment to ban new coal licensing, as you've already heard, will not impact this because this is remining coal tips and they do not need a license to do that, just planning permission. So it will not have an effect on this. We've also heard from previous consultation you've had, people talk about stop notices being applied in planning enforcement and other mechanisms through which this kind of sort of possibility of destabilising tips and then taking coal out could be stopped. We've also seen councils refusing to issue stop notices, refusing to enforce these instruments of planning control. Councils are quite cautious about using these instruments lest it triggers a legal case and significant costs that are associated with that. So we can't rely on those planning control instruments.
Have you to come in and then we'll come back to Delith and then we'll make progress.
Yeah, not at all. That was very comprehensive. Thank you so much. That was
Yeah,
really important for us to hear it. Thank you so much. Yeah.
Yeah, just to add to that, I completely support everything that Daniel said, so I won't repeat any of that. But I do think there's a slight naiveness in some of the statements by Welsh Government that we're in a post-mining context here in Wales when we've got a Glan Lash proposal for further open cast in Carmarthenshire live and, as Daniel said, Bedwas. And I think that's with good intentions, that's what their coal policy is meant to achieve, but is not currently achieving. So, we wish we'd put coal campaigning behind us more than most people, but that isn't the case. And the Deputy First Minister in his evidence session to this committee in December confirmed that sections 34 and 43 of this bill allows for the selling of coal as part of tip stability work, which is worrying and does mean that this bill is relevant to selling coal and further coal industry in Wales. And that's why we believe that an amendment is needed to ensure that the extraction and selling of coal shouldn't be allowed under this bill. And yes, we've got wider issues with coal ban. We realise that all of that can't be achieved under this bill, but we're happy to work with the committee and, of course, the government on how we can ensure possible ways to amend this bill to avoid that unintended consequence.
Okay,
great.
Briefly back to Delith then.
Yeah,
and then we'll come to Janet.
Very helpful. Thank you so much. And the idea has been broached about the Welsh Government needing to undertake carbon impact assessments and full climate change impact assessments on the bill. Could you outline why you've taken that stance, please?
Well, yeah, we don't need to preach to this committee about Wales's global impact and the importance of tackling the climate crisis. And if this remining were to happen and extraction use of coal, it would have a serious impact on Wales's climate emissions and carbon budgets and overall our joint responsibility. So we don't want to see Wales taking a step backwards on that. So as well as sort of the amendments, to prohibit coal extraction for commercial gain, we would like to see a full climate impact assessment of this bill because of this unintended consequence. And this would be in line with the precedent set by the Finch court case judgment last year, and very happy to provide a written note to the committee on that. Friends of the Earth were legal interveners in that case. But it basically sets out that in taking decisions that downstream greenhouse gas emissions of proposals should be taken into account. And if we consider that selling of coal is a possibility under this bill, then those emissions should be taken into account. And yeah, we would welcome a climate impact assessment of that.
Okay. Janet? Well, very, very briefly then, because we are up against time.
It's very brief. I would also add that there are significant operational emissions associated with heavy earth-moving works.
Not just
so for that reason as well.
Yeah, thank you. Important point. Thank you. Janet.
In your paper, this is for Canna, you suggest the regulation making power in section 814 to amend 81(4) to amend the meaning of disused tip is not needed. Can you explain your reasons?
Yeah, happy to. Thank you. In the last half a century, since 1969, the previous TIPS bill, that definition has not been changed. They did not see it fit, or they did not see it necessary to change that definition with creating this bill either. I can't see what's going to change about TIPS in the next half a century that didn't change the last half a century, that requires the definition to be delegated to secondary legislation. The whole bill revolves around the definition of tips. If you change that definition, you change the whole bill. I can't see the basis for that.
Okay, and the power can only be exercised in limited circumstances, and regulations will need to be approved by the Senedd. To what extent does this address your concerns about the inclusion of the power?
So what I understand, or I've been advised, that it will be by affirmative protocol. So it will require the active approval of the Senedd to change it. However, I think what would be more reassuring as an added safeguard is if there's a commitment to undertake a consultation, a public and statutory consultation ahead of any sort of Senedd decision-making on it, so that the Senedd can make an informed decision on the changes to that definition.
And what additional safeguards do you consider are needed to ensure that that power is used appropriately?
I think that consultation would go a long way to providing an additional safeguard.
In your paper, thank you, you raised concern about the regulation-making power in section 8215 to remove certain tips from the application of the bill. Can you expand on your concern?
Yep, I think a legislative aim of this bill is to bring reassurance to affected communities, partly through consistency, a consistent approach to coal tips. I think that is undermined if certain coal tips are excluded from that regime. It could bring a suspicion of arbitrariness to it that might undermine that reassurance. And
again, regulations would need to be approved by the Senedd. To what extent does this address your concerns about the inclusion of the power?
Similar to my response beforehand, I think that there should be a consultation that would precede that. I also understand it's by affirmative action. And that consultation should specifically focus on the communities living nearby the tips in question.
And what additional safeguards do you consider are needed to ensure the power is used appropriately?
Consultation. Yeah, that consultation.
Same again. Yeah, okay. Thank you.
Consultation is the key.
Julie.
Thank you. I'm going to ask about the register of disused tips. The Law Commission recommended the establishment of a register, a comprehensive register of all disused tips. The bill only provides for tips that are a threat to human welfare by reason of instability or could pose a threat in the event of instability to be included. So what's your view on this approach?
Well, we agree with the Law Commission that there should be a comprehensive register. If the work will be undertaken anyway to identify these, it's better for the public and nearby communities to know, yes, my tip has been recognised, it's not at risk, but it's on the list. But also in terms of this bill is meant to be about preventing issues. And it would be useful to have a comprehensive register for any proposals, any planning proposals, or any developments that companies or anyone else is considering, that they can then look at the register and work out if that impact is on or nearby a tip. So for that preventative reason, it would be worthwhile to have a comprehensive register to avoid these issues coming up, avoid causing harm or damage to tips.
But what about the issue about restricting them to the threat to human welfare?
Well, I think in terms of how we've discussed the issue of the definition of human welfare and potentially including environmental harm as well, then presumably the same issues would apply. But if we don't have a comprehensive register, we don't know they're there, or people, if local authorities looking at a planning application won't necessarily know to take that into account and to consider that impact on tips, even if they're not currently identified as at risk, whether they could be made at risk. So I think it's just as relevant in those situations.
Yes.
Very brief additional note. I agree with everything that Harper said. Under the definition of welfare includes serious property damage. I would just be interested to find out whether property damage includes death or damage to livestock on common land as well, whether that's included within that definition of property.
Okay. Okay, diolch.
Turning to the assessment regime that's set out in the bill, do you think that, as it's drafted, that is going to be robust enough in terms of coal tip safety? Oh, I'm saying coal tip safety, in terms of tip safety.
Yep. So I've been advised that the preliminary desk-based assessment will include a report from the Mining Remediation Authority following their walkover of the coal tip. So there will be a physical inspection component to the preliminary desk-based assessment. I think that is important, and I think that there does need to be a physical inspection component to that initial assessment. I think things can be missed if it's just on a desk. Call me old-fashioned, but I think you need to see it with your own eyes.
Could you tell me again who told you that? Because we weren't sure whether that was the case.
We were told it by a civil servant in a meeting last week.
It's useful to have that, to know that, because we weren't sure of it, so that's useful.
Yeah. Because we agree. Well, sorry, I can't speak for the committee, but I certainly share concerns that we had evidence last week, didn't we, that there were maps that didn't include certain culverts and mines and stuff, and the maps weren't correct. So, depending on a desk-based exercise, isn't always, as robust maybe as some people would wish.
And our experience of open cast coal mines very much attests to what's written on paper isn't always what's happening on the site.
Okay.
Would you you'd compare with that? Okay, so that's useful to know that I think that I can take it from both of your evidence then, that the physical assessment of coal tips specifically rather than other disused tips is going to be of fundamental importance. And again, we will clarify that again with the government. That's really useful. Finally, for me then, in terms of producing that report based on the preliminary assessments of all disused tips, the Deputy First Minister has said in correspondence to the committee that there's no public interest in general publication of those reports. Well, I can imagine what your view might be, but please, so we've got it for the record, what would your view be on that?
Well, having worked with communities for a number of years on all sorts of different environmental justice issues of transparency and access to information just comes up time and time again, and where that transparency isn't there, it creates distrust and fear and concern in local communities. So when these reports have been prepared, I'd say there is a significant public interest in making them available, whether it's for reassurance that everything's been considered and there isn't a risk, or for awareness that there may be concerns. So I think if you spoke to people who lived near tips, they would be interested and think there is a significant public interest. It's important to build trust with these communities and for the authority to be able to do that right from the start, to be able to be open and engage with these communities. And also, of course, we have the Aarhus Convention on the right to public access to environmental information and environmental information regulations, I believe that is the technical called, the EIRs, which do give public right to information about environmental issues, but it can be a case of having to write a freedom of information request to the right person and word it the right way and go back and forth, and we often hear from communities and residents that are frustrated by these processes and having to ask, and maybe something isn't available digitally, and having to go back and forth. And we don't think that's fair on these residents, so that it would make sense for these to be made public, to be publicly available.
Diolch, Daniel.
Yeah, I would just compound what you said about ERI requests. They are quite technical. They do require skill to get them right. It is easy for public authorities to discount your ERI request. There are also caps, there's cost caps on how much information you can get from them. They can take quite a long time to get hold of. If you want to appeal a refusal, that takes even longer timescales. So there is a barrier to ERI requests. I would also say it is vital that this authority centres transparency. That is transparency to the public, but also to civil society, to scrutinise its performance, to scrutinise its work. Civil society is a glue between public authorities and the public. They engender trust in the public authorities. So I would hope that this authority really promotes this kind of scrutiny and working with civil society and doesn't become prickly or defensive as we've seen some authorities do in the face of civil society scrutiny. Thank you.
Yeah.
Can I just, and I know we want to make progress, I just want to push back a little bit because clearly you're keen on non-coal tips to be included as well as coal tips. So that takes us from 2,500 to about 20,000 coal tips. You're not content with desk-based assessments. You'd like, boots on the ground to assess those. And you want to expand the scope beyond human welfare. I mean, as much as I'd support every one of those, is that really practical for one authority to be able to do that, in a meaningful way? All of that?
Well, I don't think you're suggesting changes to the assessments, and if that work has been undertaking, it's a case of publishing them. So I don't think it's significantly changing that. I do recognise that changing definition or expanding on human welfare would be additional, but if we're going to set up a new body, we'd rather get it right the first time and take into consideration all of the relevant threats.
Yeah, okay. Very briefly.
Yeah, just briefly, because we've talked in the past about having a public register of assets, of culverts, ditches, mines, because people on the ground, if it's open access, they walk these areas. They know if there's going to be heavy flooding, what to look out for, where, but they'll need to know who owns them, what the issues might be. And sometimes those local people with the local knowledge and local interest, well, because we said they need to know who owns them, where to go to in an emergency. We've discussed that in the past. So perhaps if they have this information on the public site, it means that they're part of all that too. Yeah. That's just my input.
No, you're right. I mean, it's all about access to information, isn't it? Yeah. Again, publicly available. Yeah. Okay, thank you. Janet.
Notwithstanding your concerns about the timing of the inclusion and evidence based for non-coal tips in the bill, do you support the creation of the Disused Tips Authority, with the main objective of ensuring disused tips don't threaten human welfare by reason of their instability?
I think we've spoken quite a bit about that at the start, haven't we, really? Yeah.
There's nothing more on this.
Okay. Can I ask you about appeals, then? Because in your paper, you emphasise the need for the grounds of appeal against the Section 33 notice to be clear and pragmatic, so that it avoids unmeritorious appeals which seek to delay operations. So to what extent are you satisfied that the ground set out in Section 36 actually meets those criteria?
Yeah. So I think that the grounds as they're set out are set out wide enough to allow appeals that are designed to delay works and to delay the costs that come with those works. I think that is a risk, and we've seen it happen. We saw it happen in Foss of Ran, and I understand that the nuts and bolts of the appeal process are being worked out currently, and hopefully some of those workings will reduce the possibility of this kind of gaming the system type appeals. I think part of the incentive, though, to launch an appeal for the purpose of delaying works will be reduced if the appeals are dealt with in a timely way, if they are dealt with promptly. Where those delays in hearing appeals and considering appeals take a very long time, it increases incentive to launch an appeal for that purpose.
Yeah, okay, thank you. Joyce?
I'm going to talk about guidance, and you've sort of crossed over some of it already, but a lot of the detail to ensure the effective application of the regime, for example, assessment, monitoring and management, which you've discussed, it will be included in guidance issued at the discretion of the Welsh ministers. Is there anything you want to add on that?
So, yeah, there is a lot of guidance, isn't there? Yeah.
Raise a question.
Yes. I mean, we're pleased to hear that work is underway by civil servants on some of the guidance, and I think I heard that the committee would be able to see draft guidance.
There's been a commitment to share it with us, albeit after being able to test it with witnesses, but at least it's been offered to us.
Yeah, but that is at least a welcome, and yes, it is crucial that there's scrutiny by the Senedd, but also involvement of the other stakeholders and experts in developing and preparing the guidance. So I don't think that the authority can work without a lot of this guidance. It's so broad that it is absolutely necessary. So I would question where there might be a duty to prepare rather than an enabling power. And with timelines, we like timelines, as you know. As
we do as a committee.
And also, although, yes, we understand from this government work is underway, things are happening, but we do have an election in a little over a year. So we do need those assurances for whoever forms the next government, and all the actors involved, including communities, local residents, need certainty that this work will continue and can happen. So I would urge you to look at those different guidances in this bill and ensure that there are timelines or there are duties where that is essential.
Yeah.
And I would just add, obviously there is a balance, and you heard this from Bob Lee earlier, between making the bill flexible enough to adapt to future challenges, but also making sure that it is open to scrutiny and cannot be arbitrarily changed from what the Senedd thinks that they are passing. I'm not sure that balance is right. I think that the guidance might be too broad. I'm also mindful of the election that is coming up in around a year's time, and the potential to change quite substantively the work that the authority does by how broadly drafted the guidance is.
Thank you. Okay, Julie.
I wanted to ask about categories of disused tips. What is your view on the approach to categorisation included in the bill?
They seem intuitive, more intuitive than the preceding categorisation. Other than that, I have no comment to pass on it.
Right. Yes, I'd agree, and they also work better bilingually than use of the English ABCD alphabet.
Yes, I hadn't thought of that.
So
actually.
yeah, you end up with an abaca categorisation. So yes, 1 to 4 with.
But there is a fifth serious. As well, isn't there?
And yes, of course.
Does that need to be sort of more? Government need to be more upfront about that fifth category as well, because it is a category.
Yes, I hadn't realised that until hearing the evidence in this committee, so it would be worthwhile making that clear. But but using numbers with 1 being the most serious does seem logical and common sense.
Okay, Colin.
Do you think the bill provides the authority with sufficiently strong powers to ensure tip safety going forward? And if not, how should the bill be amended to address this?
Well, I think we raised this as a sort of open question in our written submission because we don't have the legal expertise to analyse. So, look, you've got a legal commission and Ducaila as well. But we have experience of current enforcement within the planning system and things like that. So we're very aware that good enforcement is absolutely crucial. And we're interested in the reference to civil sanctions and things like stop notices that Professor Lee made earlier. So that would be a good additional tool to add into the bill. And I think we've just got to be ready for all possibilities. We've seen from some of the data provided by the Deputy First Minister about ownership. It's a very complex situation, and it would be worthwhile to give the authority as many tools as we can for possible future use. And I think that including civil sanctions would make sense.
Okay. And just finally, the importance of community engagement, ensuring tip safety operations prioritise minimising potential impacts on the well-being of communities. So how can this be ensured then, going forward?
Yeah, absolutely. So where those stability works, those maintenance works are significant, it can involve heavy machinery, earth moving, that creates noise, dust pollution, disruption for local communities. They're not going to be reassured if they face this kind of disruption to make stable tips in their vicinity. I think it would be good to have on the face of this bill considerable weight given to minimising that disruption in any planned works. So we're not talking about emergency works here, where a slip might be imminent or having just occurred, but those more planned work that would normally go through a planning system. I understand that there are safeguards within the planning system to minimise these kind of impacts, but we've also seen the same planning system authorise open cast coal mines within the stone's throw of people's houses. So I think that there needs to be a heavier emphasis to deliver that reassurance that the bill is aiming to do so. And that should be on the face of this bill, but can also be issued in future planning guidance. And that would materialise in greater consideration given to that community disruption and in the application of Section 106 conditions.
We've had petitions regarding increasing buffer zones as well to mining because they're so narrow and the impact they have on communities.
So would you expect remedial works also to be considerate of human welfare then? I mean, if you're thinking of the scope, then it's not just what might happen, it's as you do the work as well. It's just as relevant.
Yeah. The process of carrying out the work should be done in a way to minimise the disruption to people and things like air pollution and access to green spaces as well. It's really crucial. A lot of communities, especially socioeconomic disadvantaged communities, have had developments foisted on them or things happen to them in the past, and a lot of these tips are the result of that. So we really need to be mindful of doing things differently and getting it right this time, and putting people in local communities first and foremost, and for the authority to be doing that in a proactive way and from the start. And another, we've referenced lots of legislation in terms of planning and environment. Another one is the Wellbeing of Future Generations Act, and presumably as a new public body, this authority will be subject to that act and will need to act in accordance with the ways of working, including involvement and participation in that act. So maybe we can draw that out more and make that clear as the bill goes through as well.
Yeah. Okay. Any further questions from members? Dan first, then Carolyn.
Yeah. We've spoken about lots of the potential and intended consequences of what's in the bill. Are there any missed opportunities of things that you think should have been in the bill but are not?
It's a difficult one because it does come down to that scope and making it workable. The committee are aware when you had the inquiry last summer into the legacy of open cast mining sites that we were hoping that remediation of those sites could be included in this bill. We recognise that it's not within the remit of the authority, and that would have significant cost implications, but the sites still need it, so that issue still needs to be resolved and dealt with for the sake of those communities. The open cast sites, with the exception of Force of Ran and Glanlash, would come under the remit of this bill. They are disused tips, but the fact that this is all about stability work rather than restoration might mean that it's less likely to deal comprehensively with the matter. And then, of course, Force of Ran remains as a significant concern that won't be touched by this bill at the moment.
Sure. Okay.
I was going to ask the same question because that was right with the previous person as well. That remediation should be part of the authority as well. I've talked in the past that planning officers will oversee planning applications. They should follow it through to make sure that what's built is built, and then there's more ownership of it as well. And again with the authority, if they make sure that they're regulating it, but that remediation is also covered, because I think that's such a big part of it as well. So
yes,
can I come in on that?
Final word to you now. Yeah,
I'd agree with that. Obviously, expanding the bill to cover environmental considerations might make it unfeasible, but even the safety risks associated with not just coal tips but also open cast coal mine sites. We've spoken with local people. We've visited these sites that are supposedly restored. We've seen broken down fences. We've seen lifebuoys out in the middle of these very deep, very cold lakes. The Welsh Government has said that They will commit to making the Welsh countryside a safer place by dealing with these sites, these under-restored sites. We would welcome the Welsh Government to apply a timeline to that. As we always like timelines to that commitment. And I would also add that currently Fossa Fran is looking at a downgraded restoration plan. It's looking at reducing it by tens of millions of pounds. That will add new coal tips to this regime. So right now you're looking at over the next few years. More tips will be added to this regime. More tips are currently being created if that application is allowed to be passed. And that is being considered on the basis that the company cannot afford to put right that site. And we have yet to see any evidence from that company at all that is unable to finance that work. We hope that the Welsh Government will investigate those financial claims because it's tens of millions of pounds worth of restoration at risk here. The local council has refused to take that action. We hope that the Welsh Government will step up and do that to protect those local communities in Merthyr Tydfil. Aberpergam is also currently expanding their coal tip. So that's still growing. We'll see what happens in 2039 when the planning permission for that coal mine closes. Hopefully that coal tip will be returned, but it's not been a good track record. And we'll see what happens with Glan Lash open cast coal mine, which is currently applying for an extension. If that gets refused, we'll see what happens with that site and its restoration.
Okay. Well, there we are. That's something for us to reflect on as we bring this session to a close. Can I thank you both for your attendance and, as always, for the valuable evidence that you've shared with us, both in written form and, of course, expanded on orally this morning. Feels like afternoon still this morning. There we are. Diolch yn fawr iawn i'r ddau ohonoch chi.